Hi, you're watching Bloomberg Quint. I'm Menaka Doshi. Over the past decade, enough has been said about India's infamous retrospective tax law on indirect transfers. Or so you think. Well, not for the Indian tax department, it turns out. Despite solid losses in the bilateral treaty cases under international arbitration brought by Vodafone and Cairn, the Indian government will not give up. It has appealed the decision by the Permanent Court of Arbitration in the Vodafone case. And given that the damages in the Cairn matter are far more significant, over $1 billion, it is expected to appeal that loss as well. So there are two big questions that I'd like to pose today. What are the implications of the two decisions, the two big losses that India has faced at the hands of Vodafone and Cairn? And the second question, for a government that intensely disliked the retrospective law, why does it continue to defend it? To answer these two questions and many more, I hope, I'm joined by Cairn Counsel Arvind P.Datar, who's also a senior advocate and well-known, as you know, and Promod Nair, an advocate with experience in international law and treaty arbitrations of Arista Chambers. Gentlemen, to both of you, a warm welcome. Mr. Datar, in this discussion, you're going to play two roles for me. One is as Cairn Counsel, to begin with, highlight the important elements of the Cairn order, 570 pages, I know, but what you thought were the most critical bits. And then subsequently in the discussion, I will ask you to wear your expert tax hat as well and try and look at some of these issues objectively. But first, let me ask you for the important elements of the Cairn order.
Well, first of all, nice to be back on Bloomberg after a long time, and nice to be with Promod Nair as well. Thank you all. Coming back to the Cairn order, as you say, it is 570 pages and almost 3,000 footnotes. It's very, very detailed order. But at the end of the day, the crux or the core of the order is that the retrospective amendment in 2012, which made transactions in 2006, which were completely non-taxable, completely in order, approved by the FIPB, they became taxable in 2014 retrospectively with tax, fine and penalty of about 11,000-12,000 crores. And in the India-UK bilateral investment treaty, as in most treaties, Article 3 is a simple article which says that each country will give investors of the other country fair and equitable treatment. So Indian investors in the UK have got the legitimate expectation to expect that their investments will be treated fairly. So, for example, investments of Tatas or Birlas or the Reliance in the UK can't be expropriated. They can't be subject to unfair treatment. That will be a violation of the obligation. And vice versa, India versus Cairn. So, the moment the retrospective amendment came after Vodafone succeeded before the Supreme Court, now the only thing was to invoke the bilateral investment treaty and have the arbitration. Vodafone went to Singapore, Cairn went to the Netherlands, and that's where the thing. So at the end of the day, what the tribunal held was that any retrospective amendment violates the FET clause, the fair and equitable treatment clause, and secondly, they said that any retrospective amendment violates legal certainty, which is one of the 5 principles of the rule of law. Every country is expected to have a rule of law. That's access to justice, fairness, proper treatment, and so on, and legal certainty. So they said that this very thing of certainty, in 2006, when Cairn sold its shares overseas, the law was very clear. The shares were not situated in India, so there was no transfer in India. There was no capital gains in India, and that's how it was not taxable. But in 2014, what you do is you pass a law. Retrospectively, you say that every foreign share, if it has some assets in India, is deemed to be an Indian share and tax. So that was the basic point. So you can read 570 pages, but at the heart of it, this was the problem. This was the problem. And then, of course, the measure of damages was basically matter how to calculate damages, and it came to about a 1.2 billion.
All right. So just to sort of complete the story and the look back that you've given us, Mr. Datar, at what's happened over the last decade or so, is that the government, sort of seized the shares that Cairn owned of that restructured entity and not only expropriated the dividend on it, but eventually a couple of years ago also sold those shares. And it is that money that the arbitral tribunal seeks to restore back to Cairn as part of the damages awarded in this matter. Am I correct?
Partly, yes. The other thing is that in 2014, the Cairn, there was a buyback of shares, and Cairn could have sold his shares at that point of time. These shares were attached under Section 281B of the Income Tax Act, and Cairn could not sell it. And if it had sold the shares at that point of time, it would have got 9, $80 million, let's say $1 billion, which you do not get. So this was damages by way of restitution, where Cairn would have been in the place where it should have been had it been allowed to sell the shares. So department just attached the shares in 2014. I mean, even before the assessment order was passed, the shares were attached. And then in 2017, they sold those shares. That's how the damages were.
Mr. Datar, explain one element of this order for me. Fair and equitable treatment that used to, that is and continues to be even part of the model BIT, but that is the provision under which this case has been brought. Does that imply fair and equitable treatment with all other investors? Because there are several investors that have faced the wrath of that retrospective tax amendment. And so in many ways, people might say this is quite equitable. Cairn, Vodafone, and dozens of others suffered at the hands of that retrospective amendment. So why should Cairn, be spared it?
No, because Cairn invoked the treaty. It's up to you to invoke your treaty or not. Suppose, for example, I was a German investor and I suffered retrospective amendment. If the India-German treaty has an FET clause, which it should normally have, it's up to you to invoke that remedy. It's a remedy open to you. And so,
yes, and every single bilateral investment treaty would have a fair and equitable clause. It's fairly standard.
99.99%. That's, I think, the fundamental. See, 99% of the treaties will have an FET clause. They will have an expropriation clause that assets of a foreign investor will not be expropriated without just compensation. So these are basic clauses which are there in all the treaties.
Okay. In your opinion, Mr. Datar, what conclusions can we draw from the government's loss, not just in the Cairn case, which you've represented, but also in the Vodafone case?
Well, I think that the important lesson to be learned is that when we make a law, we have to see all the possible consequences of the law. If you make a retrospective law, you have to take a complete impact assessment. Suppose I make this law retrospective. Am I violating a treaty obligation? Am I doing something which is not correct? To give you a proper example, in Mongolia, for example, Mongolia had gold reserves and Russian investors invested in Mongolia. And the price of gold was very low. Suddenly the price shot up. It went up by 15, 16 times. And these investors made huge gains. And Mongolia increased the taxes very sharply. That was challenged as violation of FET clause. They said, look, when we came into Mongolia, the tax was say X%. Now you can't make it 10X. That's completely unfair. But the tribunal said that the right of taxation is a sovereign right. No investor has a right to expect low taxes. You can't say that I came into India in 2000, the tax were low, tax will continue to be low. That is a ruling of the international law. But the tribunal said, if the laws are retrospective, it's a different story altogether. So this red flag was already there on retrospective taxation internationally. And I think anybody, for example, suppose you as an Indian investor invest something in the UK. Let's say today you invest 100 million pounds. And in 2030, they tell you that what Doshi invested in 2020 is a taxable thing and they levy tax on you from 2030 backwards with interest penalty. Would you call it fair? I mean, ask a simple question. This is let the shoe be on the other foot. If the same thing was an Indian company investing in the UK and the UK government had retrospectively amended the law and levied a 40% tax 8 years in reverse gear with interest and penalty, can you call it fair and equitable? So,
right.
See, and you call sovereign right to tax. Nobody disputes the sovereign right to tax, but every treaty is a surrender of sovereignty partially. We both reduce our sovereignty for mutual benefit. We say, I won't tax you, you won't tax me, and under these conditions. That's what a double taxation treaty is about. That's what a BIT is all about. And we signed more than almost 100 treaties. And we got a lot of money through these treaties. What's the India-Mauritius double taxation? It has brought in billions of dollars of investment.
All right, fair enough, Mr. Datar. The point that you made about every treaty being a, sort of a giving up of sovereign rights to some extent, partial, to international law is where I'll come to that point in just a bit when we talk about the government's grounds for appeal. But before that, Pramod, we know what, the Cairn order, maybe not all 570 pages, but as Mr. Datar has given us a gist of it, we know very little except for the operative part of the Vodafone order, because that has continued to remain very secret and confidential. What conclusions do you draw from both those outcomes?
Well, I think in both cases, I think what the tribunals concluded was that India was in breach of the fair and equitable treatment guarantee that is contained in each of the treaties, and on that basis, India was held liable. In the Cairn case, there was a monetary award because losses had actually been suffered by the investor, whereas in the Vodafone case, there was a tax demand, but the tax demand was not actually enforced. So the tribunal was content with simply ordering declaratory relief, saying that India ought not to enforce the tax demand, and that was the nature of relief that was granted. Well, I think in terms of looking forward, I think you asked a very important question: what conclusions can we draw from the decisions of these two tribunals? I think one point to bear in mind is that there is no formal system of precedent in investment treaty arbitration. One tribunal's decision is not binding on another tribunal. I think the main reason for that is that these decisions are rendered under different legal instruments. The Vodafone case was rendered in the context of the India-Netherlands BIT. The Cairn decision was in the context of the India-UK BIT. So they are different legal instruments. The language of the relevant provisions in each of these treaties are rather different. And that's one powerful reason as to why there is no formal system of precedent in the system of investment treaty arbitration. But having said that, I think it's quite common for tribunals to afford weight to earlier decisions on comparable issues by other investment tribunals. So a lot of arbitrators feel they have a duty to contribute to the harmonious development of investment law so as to foster predictability. And therefore, at least in the informal sense, previous decisions will have a huge amount of persuasive effect on other tribunals which are called upon to deal with the same issue. And therefore, I think there's no avoiding the fact for the Indian government that these two decisions will play a fairly powerful role in guiding decisions of future tribunals which are called upon to decide a similar issue.
Pramod, the fair and equitable clause, to the best of my understanding, is in every single international treaty that India had signed before, and it persists in the model BIT as well, even though in the model BIT of 2016, tax has been removed, and I put it very simplistically, but tax has been removed from within the purview of arbitration under the investment treaty, or tax-related issues, let me put it that way. So, given that almost every investment treaty, at least so far, that India has had with other countries has fair and equitable. And given that it isn't just tax that we've legislated on retrospectively, but our courts themselves have sometimes taken away licenses retrospectively, what kind of precedent value could these two decisions have?
Well, I think they would be persuasive, which is what I mentioned. But I think it is also important to note the differences in the language of the treaty that a particular tribunal is called upon to deal with. So, for instance, I think there are important differences between the India-Netherlands BIT and the India-UK BIT. So, therefore, whilst India may have a more powerful argument under the India-Netherlands BIT to say that tax disputes are outside the scope of the state's consent to arbitrate certain kinds of investment disputes, what was argued now that the Cairn order is public? I think what India argued was that there was no express exclusion of tax disputes from the scope of dispute resolution under the treaty, but there was some sort of an implied exclusion, which I think is a more difficult argument to sustain. As far as the Vodafone case is concerned, I think in India is probably on a stronger footing. There are other differences between the two cases as well. So, for instance, I think a very strong challenge that was mounted by India in the Cairn case was that the transfer of shares amongst non-Indian entities would not constitute an investment in India. If you look at it from a slightly dispassionate view, on one hand, you have an investor which is saying that the particular transaction is not subject to tax in India because the transaction did not happen in India. On the other hand, the investor is saying that it made an investment in India and is therefore entitled to the substantive protections of the BIT. And India's argument was that these indirect holdings of investments would not constitute a protected investment for the purpose of the India-UK BIT, and therefore indirectly held investments or investors who hold such indirect investments should not be allowed access to the substantive guarantees that are contained in a BIT. So these are questions that will have to be decided by other tribunals where similar arguments are being made. They may also have to be decided by the courts where a challenge to the arbitral award may be filed. So I understand that India has already filed a challenge to the Vodafone award in Singapore, which was the seat of the arbitration. In the Cairn case, the seat of arbitration was The Hague. And I think it's quite likely that the Indian government will decide to challenge the Cairn order as well. And that challenge would have to be filed in the Netherlands.
All right, great. So you've pointed out where the cases are similar and therefore, could have persuasive value, and where they're dissimilar. So therefore, arbitration tribunals would look at the facts of the case or the merits of each case differently. Mr. Datar, would you have any, sort of intimation from the tax department on whether they're seeking to appeal the Cairn decision as well?
No, I have absolutely no clue, because award has just come in on the 22nd December or 23rd December. So I think they may have a statutory time to file an appeal in Cairn. So I don't know what they're going to do.
But do you think it is fair to assume, sir, that given in the Vodafone matter as well as in the Cairn matter, they've argued jurisdiction of the tribunal, saying that this is a tax issue and therefore would not necessarily come, and we have full sovereign right to pass the tax law that we want to, whether it's retrospective or not, that this should not therefore come within the purview of the International Arbitral Tribunal, under the treaty. Do you think that that would be their argument in Vodafone in the appeal, and similarly in the case of Cairn?
No, they did raise the argument, I think, in Vodafone and in Cairn, that taxation is a matter of, is a sovereign power.
Right.
Therefore, when I tax somebody, it's my sovereign right, and that can't be subject to arbitration. But that has been rejected, not only in our case, but you see, when we did the research for the Cairn matter, I found that there were totally 32, I mean, apart from Vodafone and Cairn, there were 32 international investment treaty arbitrations involving tax disputes, 32. And out of 32, 17 went in favor of the state. The claims were dismissed in 17 cases and allowed in 15 cases. So it was a kind of an even balance. So nobody questions the country's right to tax. What they say is, by exercising your sovereign right to tax, are you treating the investment unfairly? Are you not unfairly, inequitably? Are you violating the FET clause? Now, this FET violation can come from a pollution law, it can come from a labor law, it can come from a tax law, it can come from a contract law. So this fair, equitable treatment has to be to the investment as a whole. So there are treatments, there are cases which have come under because of the energy cess. There are cases which have come from Russia because of the way they treated the contractual obligations and so on. So this tribunal also made it very clear that we are not questioning India's power to tax. All we are saying is, if you subject a foreign investor to retrospective taxation 9 years down the line and make him liable to something which was not taxable at that amount of time, that will be that would violate the FET clause. And that's the law laid down by them. So this argument that it's a sovereign right, therefore not arbitrable, is not correct, because they make it very clear. We are not saying you tax what you want. Like in Mongolia, if they had made this Vodafone law prospective, like Mr. Nair said, mentioned that the whole issue was the shares were transferred in the UK or shares were transferred in the Cayman Islands. Now the question is, can India tax it on the ground that those shares have got subsidiary companies which have assets in India? So the question was there an indirect transfer? Like suppose tomorrow I buy 30% of Tata Motors. Am I buying 30% of the Jamshedpur factory? That's the question. The government said it's an indirect transfer, and they said we have always had this indirect transfer, but they could not get any evidence of that. See? And in Vodafone, they made it very clear that indirect transfers are not transferable. They said share is a share. You look at the thing, don't look through, don't have a dissecting approach and go to the assets below the shares. So all this was laid down by the Vodafone Supreme Court judgment. But unfortunately, they amended the law retrospectively, which of course was left the whole international community absolutely aghast.
No, Mr. Datar, so I'll just come back to the issue of appeal, both in the Vodafone matter, and I think the expectation is that since they've appealed Vodafone, where the damages are costs and very, very small, they definitely will appeal Cairn. You believe that if they do appeal it, their decision to agitate on the grounds of jurisdiction will be a weak one?
Well, I don't want to speculate. It will not be fair since I appeared for Cairn. It will not be fair to comment on the merits of their appeal. Actually, very honestly, I have not seen the Dutch law on appeal because it's a judicial review. We don't know it's an appeal. It's a revision. What kind of a judicial review is there? Will it be a merits-based appeal where they can go into the findings, or it's just going to be like Section 34 of the Arbitration Act? You can't go into the merits of the decision. You can only go into the decision-making process. So what kind of an appeal it is, we don't really know. What's the limitations of that? So I shouldn't comment unless, because I've not read the Netherlands.
Okay, so let me toss it over to Pramod, because from what I understand, based on my research, Pramod, in the case of Vodafone, the Singapore court might still be able to go into the merits of the case and the merits of jurisdiction, even at the appeal stage, but that might not be the case with regards to Cairn if the government were to appeal. Could you explain to us what grounds for appeal a government may have in both of these matters, and whether those grounds are very narrow and technical?
Certainly, I think it's important to make a distinction, as Mr. Datar mentioned, between a challenge court considering issues of merits and considering issues of jurisdiction. As far as issues of merits are concerned, I think the view that is taken in most countries which are parties to the New York Convention on the recognition and enforcement of arbitral awards is that the merits are largely a matter for the arbitral tribunal, and national courts should not be second-guessing the decision of arbitral tribunals on merits. Whether it's a commercial dispute or whether it's an investment treaty dispute, that is the yardstick that is normally followed, because that is something which also respects the parties' agreement. The parties' agreement was that these disputes would have to be resolved by arbitration and not by a national court. So therefore, to give effect to that agreement to arbitrate, national courts do not generally review matters of merits. On the other hand, as far as jurisdiction is concerned, I think national courts are conscious of the fact that the jurisdiction of an arbitral tribunal is based on consent. Now, if that consent is a qualified consent and not an absolute consent, that is an important factor which needs to be kept in mind in ascertaining the scope of jurisdiction of an arbitral tribunal. So if India has agreed to arbitrate international investment disputes with a foreign investor, but conditioned that agreement by saying that tax disputes are not arbitrable, I think courts would have to give effect to that qualifier. Now, the issue in these cases is whether such a qualifier exists or not, and whether such a qualifier exists, one, for the consent to arbitrate, and second, whether it also qualifies the scope of the substantive protection itself. Does tax disputes, does the protection of fair and equitable treatment not apply as far as tax disputes are concerned is also a question. Now, Mr. Datar did mention that, and I think there is an important aspect of Indian law which is relevant here, which is that there is no equity in a tax. So you may have the principle of fair and equitable treatment, but as far as a foreign investor, or for that matter, any investor in India is concerned, whether it's a domestic investor, decides to invest in India on the basis of a particular legal landscape which exists. Now, investment treaties are not supposed to be insurance policies for all kinds of business or legal risks that exist, and an investor is supposed to take the legal system as it finds it. So retrospective legislation is not uncommon. This is not the first instance of retrospective legislation in India. Previous instances of retrospective legislation have actually been upheld by the Supreme Court. There are a number of decisions to that effect. And therefore, there could be certain such arguments that could be made by India on the merits of the cases as well. But I think India's strongest point would probably be to say that it did not consent to arbitrate tax disputes, that these are disputes that are essentially tax disputes, and therefore the tribunal did not have jurisdiction to rule on them. And I think as far as the courts in Singapore are concerned, they take an involved approach to a challenge to an award on jurisdictional grounds. They would consider the issue of jurisdiction de novo without being influenced by the decision of the arbitral tribunal. But there is a much greater amount of deference as far as the tribunal's treatment of the merits of the case are concerned.
Okay, so can you explain to me, Pramod, in our treaties, would as you've just pointed out in your answer, that tax, was not something that India had. I mean, did we make it clear in our treaties that we would not want to arbitrate tax disputes?
I think that's where the ambiguity lies. I mean, to be honest with you, I think the language is not as clear as India would have liked it to be, both in the Vodafone case as well as in the Cairn case. And that's why in the Cairn case, they made an argument based not on the existence of an express exclusion of tax disputes. I think the argument was that there was an implied exclusion of tax disputes from the scope of disputes that could be submitted to arbitration. Whereas I think in the Vodafone case, I think India probably has a more strong case to advance before the Singapore courts.
Okay, India has a more. Can you explain that? Sorry, I missed that bit. Why does the Vodafone case give India, sort of more grounds?
And that's because Article 4 of the India-Netherlands BIT does state that tax disputes fall outside the scope of protections of Article 4.1 and 4.2, and Article 4.1 is the fair and equitable treatment standard. So as far as India is concerned, what India could argue and probably has argued in the Vodafone case before the tribunal, and what it may seek to argue again before the Singapore courts, is that fair and equitable treatment is something that India has guaranteed to all investors, except when it comes to taxation matters, and there is therefore no fair and equitable treatment guarantee that the Indian state has agreed to extend to foreign investors when it comes to taxation matters.
And this would not apply to the Cairn matter if the government were to appeal the Cairn matter. And the Cairn matter does not go to a Singapore court. It goes back to a court in the Hague in Netherlands. Is that correct?
That's right.
Okay. So you're saying, again, even in the appeals, one cannot generalize that it will likely be jurisdictional grounds, and even at the appeal stage, the jurisdictional grounds will be looked at similarly.
Yes, I mean, I think there are important differences between different jurisdictions, and I think the fact that the two seats are different will have consequences for how
basis likely to be?
I would think in both jurisdictions a maximum of 2 years.
Okay. Mr. Datar, any thoughts on this appeal process and how you think you expect it to evolve from here on?
Yeah, you see, the only thing is I want to make it very clear that this question of tax disputes being outside the arbitral investment treaty, one has to make it clear this is not a tax dispute. The Cairn dispute is pending in the Delhi High Court. Whether they're liable to pay tax, etc., etc. What is the tax? What's the computation of capital gains, etc. is pending in the Delhi High Court. So this is not a tax dispute. The question is, if one country levies a retrospective tax and makes a demand, is it violating the FET clause? So we made it very clear that we are not disputing whether the section 9 is correct or section X is correct or section Y is correct. That is not the jurisdiction for the foreign arbitral tribunal to get into. That is for the Indian courts to decide, and the Cairn dispute is indeed pending before the Delhi High Court now, as we speak, and it will eventually go to the Supreme Court. But what is this international treaty is that by levying a retrospective tax, you are violating the FET clause. And mind you, the retrospective tax has not been challenged by Cairn. It has not been challenged by Vodafone. The retrospective validity has not been challenged. We accept the tax as it is. If this is the law, what happens? So if you make a law, say, on pollution or on energy or something like that, it's not an energy dispute or it's not a pollution dispute. It is whether this law has impacted the foreign investment and made it unfair.
But Mr. Datar, I think if I'm correct, and I understand what the nuance Pramod was pointing out, which may not necessarily apply to Cairn, but would likely apply to Vodafone, is that if the genesis of the dispute is tax, then it may not necessarily be something that can be arbitrable. The language is ambiguous there, but in the Vodafone case, he's saying the language is a little less ambiguous than in the case of Cairn.
Well, I don't know exactly what is the language of the India-Singapore Treaty, so I won't be not fair to comment on what Pramod has said. But okay. what I wanted to emphasize again is that one must get rid of this notion that the tribunal has decided some kind of tax dispute. It has not decided the tax dispute at all. It's not going to decide the tax dispute.
The genesis of the dispute, Mr. Datar, is tax, isn't it?
It is the consequence of a tax law. Has it resulted in violation of the fair and equitable treatment? There is a law that is given. That is the sovereign power. Nobody questions that. For example, the international tribunal can't say that this law is unconstitutional. It is ultra vires Article 14 or 19.
Sure.
That's not the job of the international tribunal. That's the job for the domestic courts. So what I want to see when I analyze all these 32 judgments on taxation is that no tribunal has gone into the issue whether Peru can levy a tax or Mexico can levy a tax. That is not the problem. Whether Mongolia can levy a tax. They have made it very clear. You levy a tax. You have made the tax 500%. Now then we'll check, is it violating the fair and equitable treatment? If it is violating, it has to be it has to be held to be a violation with consequences or damages or whatever they may be. So I just wanted to emphasize that no tribunal is getting into a tax dispute. But the new treaty says that anything relating to tax cannot be arbitrable. That's a different matter altogether. But the FET clause in Netherlands, as I see it, has got no mention about a tax dispute or a contract dispute. It simply says every investor can expect fair and equitable treatment of his investment. Now, if I make an investment in Indian oil fields or in whatever it is, and by levying a retrospective tax, you confiscate my shares, you do something, then you are jeopardizing my investment and you're violating the treaty. That's how the logic is. So one has to be very clear, according to me, that we are not going into the merits of a tax dispute or not. We accept the particular position.
Okay, it's interesting you framed it that way. Okay, explain to me this, and I put this question to both of you, Pramod first, and then you, Mr. Datar, is that the model BIT of 2016 explicitly removes tax from the purview of arbitration under the investment treaty, right? Now, that's explicit language from what I understand, whereas the existing language in many of the BITs is ambiguous. But fair and equitable, I think, persists in pretty much every international treaty, even in the model treaty. So if you're going to arrive at fair and equitable through a tax route under the model BIT, would you still be able to, arbitrate something like this abroad?
No. In the 2000 treaty, answer is no, because there are two important clauses in the 2016. One is the exclusion of all tax disputes. So there are certain limitations on that.
But Mr. Datar, you're saying this is not a tax dispute, right? You're saying the genesis may be tax, but the outcome isn't fair and equitable.
No, the language of the 2016 makes it very clear that if anything relates to tax, it will not go for arbitration. Okay. Even if it's got some indirect nexus, but if it's anything relating to tax, it will not be. So you can't tomorrow say that this particular tax levy, however valid it may be, violates my FET treatment. That has been completely excluded in the recent. And the other important point in the 2016 is the exhaustion of remedies rules. That you can't go to a tribunal till you exhaust all the local remedies up to the Supreme Court within a time frame. So only when you exhaust all the remedies, then you go to the tribunal. Here, for example, in Vodafone and Cairn, they could have challenged the retrospective levy in India, but they chose to go to the treaty. So that's how it. So now they say you must exhaust the remedies. You can't go for the treaty. So, like what Pramod says, 2016 they made it very explicit that if it's something to do with tax, it's non-arbitrable. Like even in the Indian Arbitration Act, if it's a matter regarding child custody, it can't be arbitrated. Some rent control legislation cannot be arbitrated. So these are things which are non-arbitrable disputes. So simply put, the 2016 says that any tax-related matter is non-arbitrable.
Okay, fair enough. Pramod, I know Mr. Datar won't answer this, but I'll sort of give it a shot with you. How high would you rate the chances of India succeeding on appeal in either of these cases?
Well, I think, to be honest, Menaka, I think it would be challenging in both because there are ambiguities in treaty language. I think India's strongest case would be one based on jurisdiction. Also because reviewing courts would normally, look at questions of jurisdiction very closely for the reasons that we've just discussed. India's strongest case would therefore be to say that the tribunal had no jurisdiction to decide tax disputes. But there are ambiguities. I mean, I think in both cases, I don't think the treaty language very accurately or faithfully records the intention of both contracting states that tax disputes are clearly outside the scope of review of an international arbitral tribunal. And I think that's where the ambiguity lies, and that's where the disadvantage for India lies. But I think despite that, I think in the Vodafone case, India probably has a stronger case on jurisdictional grounds as far as the exclusion of tax disputes is concerned. It may have a much stronger case in the Cairn matter as far as the protection of indirect investments is concerned. So that's also a jurisdictional question. So there are important jurisdictional questions which will have to be determined by the courts which are going to be called upon to review these awards. I don't want to second guess the chances of success, but in all these cases, I mean, I think it is going to be challenging for India to prevail completely.
Okay, Mr. Datar, it's going to take maybe 2 years for this appeal process to finish, right? Now, in the interim, what will clients like yours, in the case of Cairn or even Vodafone, do? Will they seek to enforce this arbitral tribunal decision? And if they were to enforce it, how would they go about doing it? Would they move against sovereign property, Indian sovereign property overseas? Because trying to enforce it in India would be very, very difficult, isn't it?
Well, I really don't want to say that because I prepared for Cairn, but I think there are enforcement processes which are there. I don't know if the appeal is there, they're going any kind of stay of the award is there. I don't know what process they're going to follow. But there are very, very clear provisions for enforcement of the award, which can include getting hold of Indian investments abroad and so on and so forth. So I don't know if they're going to wait for the appeal to pan out, or I think Pramod may be a better person to say how execution is done. But as you say, in India, it will be difficult to execute the award. Nothing prevents them from doing so. But it's going to be a difficult task to.
Okay, so let me put that to you, Pramod, in a two-part question. One, how would they go about, sort of enforcing this arbitral award? Both of these parties, would they seek to move locally, or would they seek to move against Indian assets abroad? And then in both of those situations, what would be the challenges that they face? For instance, locally, would they have to move a high court or a Supreme Court to be able to seek enforcement of the award? And would they have any success in that process? Or would the government be able to successfully argue that the enforcement of the award or the arbitral award itself is against Indian public policy and therefore there should be no enforcement?
If I may, let me just start off with the preliminary observation. I mean, I think India has a pretty good track record of voluntarily complying with arbitral awards, both in the commercial sphere as well as in the treaty sphere. In fact, the very first investment treaty award that went against India was in the case of White Industries, which was an Australian investor. And India voluntarily complied with that award without even challenging it. Though I would say that India had a good, had good grounds to challenge that award because of the quality of reasoning of the arbitral tribunal in that case. India did not challenge it, and it voluntarily complied with the award. As far as these awards are concerned, I do agree with Mr. Datar that there are going to be challenges to enforcing the award in India. I think the fact that there could be challenges pending before the Dutch courts and before the Singapore courts would be reason enough for the Indian courts to defer enforcement of an arbitration award. And even after that, I think there's this ambiguity about whether investment treaty awards are enforceable under the New York Convention in India. The Delhi High Court has taken the view that they are not amenable to enforcement under the New York Convention, which creates a bit of a vacuum as far as the legal regime is concerned. There seems to be no legal regime then for enforcement of investment treaty awards in India if that view of the Delhi High Court is also going to be endorsed by the Supreme Court. So those challenges remain. But as Mr. Datar mentioned, these awards need not be enforced in India. India is a party to the New York Convention. These two awards are most likely going to be considered to be New York Convention awards in 164 other countries which are parties to the New York Convention. And as long as the investors are able to find assets of the Indian state or its agencies or instrumentalities in these jurisdictions, they may be able to find courts which are willing to enforce these two arbitration awards against Indian assets that are present in those jurisdictions. I would imagine there is no enforcement risk as far as India is concerned. Although in the Cairn award, the award exceeds $1 billion, there should be sufficient assets outside the country that an investor can find in order to satisfy an award if it really comes to that.
Pramod, I know Mr. Datar will not speculate on this, but I'll ask you this question because it may pertain to his client. Is that how easy or difficult it is? I mean, when we in legal language say enforce the award, that means that Cairn or Vodafone or anybody else who would have won in such a treaty-led arbitration would have to seek a court in that particular country to say, let's say this embassy building, that belongs to India actually now belongs to you because it's equal to $1 billion. Is that how it works?
Not exactly, and I think the legal rules vary from jurisdiction to jurisdiction. You're right, because this is a very complicated area of the law. There are two kinds of immunities that a state has. There is immunity from being sued, and there is an immunity in respect of having a decision enforced against it. By agreeing to arbitrate, there is a waiver of the immunity against suit. So India can be sued in international arbitration, and it doesn't have immunity. But as far as immunity from enforcement is concerned, the rules vary in different countries. For instance, the position in China is that there can't be any enforcement against a sovereign or commercial asset of a state there because they follow what is called as the absolute immunity rule. In many other jurisdictions, sovereign assets are outside the scope of enforcement. So the embassy building, in your example, would be outside the scope of enforcement.
Okay, I used the wrong example. I realized at the moment I said embassy building. What other kind of Indian asset, Indian government asset or national asset could be used? Let's assume, I don't want to say Cairn or Vodafone because I know both Mr. Datar and then Anuradha Dutt at some point will also tell me, hey, look, I don't think our clients are going to go about doing anything so coercive. But nonetheless, just hypothetically speaking, if someone won and the Indian government was hypothetically not willing to voluntarily comply with that, how would they go about enforcing an award?
Well, it could be planes that are owned by Air India, and assuming Air India is not privatized by then, the assets of Air India would be considered to be assets of the Indian state. Those could be attached and sold. There are precedents to that effect, where I think the plane of the Royal Thai Prince was attached by a German court, and then ultimately that was used to satisfy the requirements of complying with an arbitration award. A ship building, a ship belonging to, for example, an Indian government-owned company can be seized. Monies that are available in the State Bank of India, etc., could be attached. I mean, there are the possibilities are endless. As long as an investor is able to show that certain assets are controlled by the Indian state, its agencies or instrumentalities, those assets would be available for enforcement and attachment.
How realistic? Okay, has this ever happened before? You pointed out the White Industries case, which is a very interesting treaty arbitration. But in that case, India voluntarily paid up. But has it ever happened before that a investor that is won or succeeded in an international arbitration based on the bilateral investment treaty has then had to enforce that award against India by taking over Indian property?
Not in respect of India, and in fact, the examples are actually going to be quite few in other contexts as well. And that's because I think as far as governments are concerned, they will probably do all that they can to exhaust the legal options available to challenge an arbitration award. But once it becomes clear that there are no further avenues of challenge, I think they would be better off complying with the award, probably by reaching a settlement with the investor, probably by having the investor discount a portion of its claim, because to do otherwise would damage the standing of the state in the international community. And that would be a danger far in excess of, let's say, the 1.6 billion that is claimed by Cairn in a particular case. And I think it's not only India, I think most other states in the world would probably take that view of the matter. And after exhausting all the legal avenues open to them, and if they don't succeed in having an award set aside, I think most national governments would prefer to just pay voluntarily and avoid its reputation as a good investment destination being, in a sense, affected.
Yeah, Mr. Datar, I'm not trying to set up a confrontation here at all between either Vodafone, Cairn and the Indian government. I'm sure the government will want to exhaust all of its legal options before it even discusses settlement. The reason why I'm stressing on all of this is because I'm trying to understand what is the value of these two orders. If in both cases, the investors are going to be hesitant about enforcing the current arbitral awards, Cairn may not have continuing business in India, but Vodafone definitely does. So they may still not want to take on the Indian government, overseas in any fashion. And the settlement 2 years, 4 years down the line, given that this matter is already protracted for over a decade, is meaningless. Then what is the actual takeaway from the loss that the Indian government has faced in these two cases?
Yes, I think I must say Pramod gave an excellent explanation of how it can be enforced. I could not say so because I've appeared for Cairn and the matter is still pending. But you see, what is the biggest takeaway is this. Now the award has been passed. Forget about Cairn and Vodafone. Let's say that a party X has got an award against country Y. Now, even if X is not able to, it's not very easy to go and attach a plane or attach a ship and so on. It's difficult. It's got its own limitations. But what is far greater at stake is the reputation of country Y against whom the award is passed. Is it seen in the international community as a country which is going to do all it can and not pay up the award? That's a big question. And I have got, though Pramod says it's not an insurance policy, according to me, an investment treaty is a kind of an insurance. That is, if a foreign investor, German investor, has the option to invest in India, Thailand, Vietnam, or Burma, whatever it is, and then it knows that, look, if I invest in India, there's an investment treaty which will protect me. If something goes wrong, I can take it to an arbitral tribunal. I can go to an independent tribunal, which is neither Indian nor German, but some arbitral tribunal in Netherlands or in some other third-party neutral country, and I can get the matter decided. And I also know that, look, if I go invest in this country and something goes wrong and I still succeed in the arbitration, this country will pay my dues. So this is the kind of image, brand building also is important for a particular country in terms of the award. As Mr. Nair Pramod rightly puts it, one thing is we'll have to see what is the effect of a country not honoring its award in the event of ultimately a matter going. So it's a very, very important matter. It's not just about executing and realizing money. It's a question of the country's reputation, about its... that's why they're now the new treaty. They say we don't want to get into tax because we may have issues on tax. That's not arbitrable. Now it's open for a new country to decide, does it want to enter into an investment treaty? It will say that, look, if your taxes are not going to be arbitrable and taxes are going to be the biggest problem in India, then I will not sign the treaty with you. And according to me, it's a huge setback. I think personally believe there's a direct nexus between the amount of investments came in and the investment treaties we signed.
Yeah.
That was a big ground for them to come and invest, because it is indeed an insurance. I have got some kind of a background comfort that, look, if I go to this country, it'll protect me.
Mr. Datar, that brings me to the last point I want to put to both you and Pramod. Why do you think the Indian government is appealing this? We know that the present government, or at least the political party and the politicians that lead the present government, have expressed their dismay about this retrospective amendment. We know that you presented that as evidence in the Cairn matter. The world knows it at large. That Mr. Jaitley, in his first budget as finance minister, had spoken of this, saying he was that he did not want to continue tax terrorism of this nature at all. So why do you think the Indian government persists in fighting this? They could have accepted both these losses gracefully.
You're absolutely right, because in 2000, in fact, the BJP party manifesto says that they will not have retrospective taxation. And to the credit of the government, there's been virtually no major retrospective taxation in the last 5 years. All credit to the government. And from 2014 till now, there's been no major retrospective law. Earlier, the unfortunate part was that if any judgment goes in favor of the SSC, you amend the law retrospectively. And I have a fair idea that when we did the statistics, we have perhaps more retrospective amendments than the rest of the world combined. That's the kind of amendments we have. We have been having some staggering number of amendments retrospective. Every judgment which went against, whether tribunal, High Court, Supreme Court, we amended the law retrospective. So the new government said we won't do it, and they have stuck to their word. In retrospect, now of course, much water has flown. In retrospect, in 2014, if they had said, look, we are withdrawing the retrospective amendment, we will not tax retrospectively, we will not make something which happened in 2006 taxable, I think the kind of investment which would have flowed into India would have been much, much more. Now look at the Pickwick situation. You had a retrospective amendment. How much have you collected from Vodafone? How much you collected from Cairn? And what is the damage to the investment climate that has taken place because of this retrospective amendment? I think the new government could have in 2014 said, sorry, as part of our manifesto, we're withdrawing it. For a few thousand crores of tax, as Pramod put it, they would have got much, much more by means of investments into India, which would have generated so much more indirect taxes.
But Mr. Datar, they didn't do it then, and they aren't giving up the chance to continue to litigate this further. Is there a legal reason for why they might not be doing so?
I don't know. See, like what Pramod said, they may have a view that they've got jurisdictional grounds of challenge, or they would say that let's try out the appeal. We've got one last remedy. Let's put our case to the appellate court. Suppose they accept, like Pramod says, that taxes are not arbitrable. Who knows what will happen? We don't know. But maybe, yeah. The other view is, if I've litigated for 6 years and 7 years, and I've got one more appeal, why not I take the chance and exhaust my appellate remedy as well?
Okay, Pramod, you want to speculate as to why they continue to persist down this road, even though they've expressed their distaste for this particular law?
And if I may just, sorry to interrupt. The other thing which I find is, in my practice, I find that there has to be, whether it's the arbitration of public sector enterprises or it's other thing, there's a complete, almost impossible for any government organization to come and settle a matter. Suppose there's a claim of 50 crores. It is virtually impossible for any PSU or anybody to come and say, all right, 50 crores, I know you've got a case, but I'll settle for 25 crores. They will not do it. They will insist on fighting 50 crores up, because a wage system, nobody wants a vigilance case. Nobody wants a kind of a mark. How did you settle it? You cause loss to the government. There are amendments to the laws which can cause serious problem to the officer concerned. So nobody wants to take the decision and say, I've got a claim for 100 crores, but I know 100 crores is not doable. It's not likely I'm going to win it. So let me settle for 35 crores.
Yeah, fair enough. This is the political cost of saying no or settling. Pramod, a quick speculation on why you think they might be persisting down this route?
I think a couple of observations. I think one reason why a lot of parties, and I'm not speaking about this case, one reason why a lot of unsuccessful parties challenge an arbitration award would be to postpone a potential liability. And especially in these cash-strapped times, I think the government has enough on its plate, especially dealing with, the economic downturn after the pandemic. I think postponement of a potential liability would be no bad thing. That could be one reason. But I think there's probably a larger reason. I think that's also one reason as to why, despite the criticism of the retrospective amendments, those were not done away with, and the government actually chose to contest this matter. And I think, in some ways, I think the criticism of tax terrorism is a little unfair. The reason being that this purpose of introducing the clarificatory amendment was to prevent multinational corporations from escaping capital gains tax through indirect transfer of shares carried out in tax havens. And just before we conclude that India is the only outlier as far as this is concerned, there is in fact a joint initiative by the International Monetary Fund, the OECD, the United Nations, and the World Bank Group. They set up a platform for collaboration on tax, and they actually released a toolkit in June 2020 on taxation of offshore indirect transfers. So there is in fact a global initiative to ensure that where the underlying economic asset is actually located in a particular country, by clever structuring of transactions.
Pramod, you're now opening up a very different Pandora's box on indirect transfers. I don't want to debate that because I don't think anybody argued against the prospective taxation of indirect transfers. The argument even in 2012 was about the retrospective taxation of indirect transfers.
I agree with that. I mean, I think that the issue is whether there are two issues there. One is whether these transactions should be taxed or not, and the second question is whether they should be taxed retrospectively. What I'm saying is that one reason why probably the retrospective taxation was not done away with was because I think the government realized that there is some mischief here which needed to be tackled. And I think Mr. Datar rightly pointed out that there was criticism by the BJP. In fact, it found mentioned in the BJP's manifesto. I think the expression tax terrorism was used in the BJP manifesto. It was in fact cited in the Cairn Award.
I'm aware of all of that. Any legal reasons for why you think that they might have felt compelled to appeal this, even if they didn't like the tax or the outcomes, in terms of impact on investment?
Well, I think there are government law officers who've gone on record to say that as far as India is concerned, tax issues are purely a matter of India's national sovereign decisions. And India has not consented to an external body, including an international arbitration tribunal, ruling on the validity or otherwise of Indian tax legislations. So I think that seems to be the bottom line for India. India, according to the present government and according to the view taken in these arbitrations, believes that the arbitration tribunal simply did not have the jurisdiction to adjudicate on what was essentially a tax dispute. It was outside the scope of its jurisdiction. And on merits as well, I think, the fact that there was a mischief that had to be taken was one reason why this may actually go through the entire gamut of challenges, both in Singapore as well as in the Netherlands.
Okay, one very quick follow-up question, because we're really at the end of time, but you've explained why this may or may not have full precedent value, right? Do you think it might be in order to ensure that their positions in other cases, because we have several BIT-related cases that are currently underway. Some have to do with tax and indirect transfers. Many of the others have to do with, let's say, for instance, court action against licenses, mining licenses, telecom licenses, etc. So do you think that it could be that the government felt that we don't want our position in any of those cases to be weakened, and therefore an appeal is absolutely necessary? Does that make legal logic?
Well, I think probably after the White Industries decision, and after it was sued in a number of cases after the cancellation of the 2G licenses, it actually terminated and denounced 57 of the bilateral investment treaties to which it was a party. So the fact is those treaties don't exist. It's a different matter that those treaties contain what is called as a sunset clause, which means that for investments that were made before the denunciation, the protections of the treaty will continue for a period of 10 to 15 years, depending on the treaty in question. Therefore, the government has not taken kindly to the fact that international arbitral tribunals are reviewing the conduct of the executive, or for that matter, the judiciary, and it has decided to opt out of the BIT system altogether. And I think as far as the appeals are concerned, I think where the government believes that there is a genuine case to fight, I think it will probably solicit advice, and where it is properly advised, it will file a challenge. I mean, it's no different from any other arbitration award involving the government, or for that matter, any private party.
So it doesn't have too much precedent value on other cases. That's the point you're making, Pramod, in short?
Well, see, as far as there is actually a cluster of cases, as you rightly mentioned, on retrospective taxation. So there was Vodafone, which culminated in the first award. There's Cairn. There's also Vedanta matter, which, and I think the award in that will be out shortly. So I think if India
that's all. No, there are no other matters now on retrospective taxation on precedent value. Sorry to interrupt. I only wanted to mention.
Please do, Mr. Datar.
No, I only wanted to mention that this case will have no precedent value because in Cairn and Vodafone they have pointed out that this is the first case where a retrospective tax of this nature has come before a tribunal. So what happens in telecom license, etc., won't apply here because this was a short point was, can you make an investment, impair investment retrospectively? That was the only point. And unless there is some other retrospective law tomorrow, it's unlikely that these cases are going to have precedential value. Of course, one precedent could be whether a dispute of tax, though it could be tax, can still violate the FET clause. That could be a thing. But I don't think that's a precedent because there are 32 cases where these tax disputes have been considered by the tribunal. Everywhere they've taken the plea of sovereignty, which has been rejected. So this is a very unique case of retrospective taxation.
Okay, then let me put the last question to you, Mr. Datar. And I'm asking you to wear your non-Cairn hat to answer this broadly because you engage with so much tax litigation, across the spectrum. If we are persisting as a government and a tax department to defend what the government itself has called indefensible by filing appeals, if we have redone the model BIT so as to move tax disputes outside the realm of international arbitration under an investment treaty, if our tax treaties themselves don't have any mandatory arbitration, then confidence, given all of this, will a foreign investor investing in India have with regards to tax and tax-related disputes and their ability to resolve them fairly?
Well, I personally feel that it will be a huge setback in terms of investment because if, say, an investor in Germany has a choice of coming to Vietnam or X country or Y country in India, and if he feels that there is no investment treaty arbitration, there are no safeguards, etc., he may think twice. It could be one of the decision-making process. Of course, eventually he may still come to India for other reasons. But if you have, in my opinion, if you have a proper investment treaty protection, I say, what's wrong in excluding, what is the justification to exclude tax? Why can't you say my tax laws will be fair? Please come to India, invest in India. I'll make sure that my tax laws are not unfair. I won't make retrospective taxation. Please come. Why can't you say that? The answer is not to simply say, throw out the tax dispute and say, I'll not arbitrate. I'll exhaust all remedies. It's not the answer. What has happened after 2016? 4 years down the line, except Belize or some country, no important country has signed a treaty with India. So we see one thing, if you want sovereignty, yes, you can have sovereignty. Then don't expect the kind of investments. I mean, if you're talking for 5 trillion economy, make in India, having goods manufactured in India by multinationals and so on and so forth, then according to me, you'll have to think differently. Don't worry about losing a few thousand crores in tax. Look at the thousands of crores you'll get in terms of GST, indirect taxes, employment generation. You got a 30-40 billion electronics market in India. Just imagine the kind of money and employment you generate by allowing the people to come in. But we're just worried, okay, how much tax I lose, and there'll be some tax dispute against me. Forget it. I mean, just think big. Be bold enough to say my tax laws are fair. I have nothing to fear.
Pramod, 20 seconds. India is an outlier in the way it's treating or dealing with many of these issues in the context of how we're looking at tax disputes through BIT and otherwise?
I don't think it's an outlier, but I think it's part of an education process for the country that there exists this international review through investment treaty arbitration. The learning curve is going to be steep, but I completely agree with Mr. Datar that probably the effect of all that is that the rule of law will be entrenched even further. So in addition to domestic courts which uphold the rule of law, international tribunals will also have a role to play in entrenching the rule of law and holding states accountable for breach of treaty obligations. And I think that's only a good thing.
And Menaka, one last point about the Indian atmosphere. I've got multinational clients. I'll just give an example of 2 of them. In both cases, just 2% of the global turnover is from India. In one case, it's 1.4, one case is 2.2% of the turnover is from India. But 95% of the litigation is in India. So that's a huge eye-opener, you see, because they find that once they come into India, they've got a customs case, they've got a GST case, they've got a tax case, they've got a transfer pricing issue. So we'll have to really think about it. I mean, why does India have more transfer pricing disputes than the whole of the world combined? We'll have to really, really rethink that are our tax laws meant for tax collection or to promote investments and to promote growth? It's a very fundamental issue.
Well, I think
Sorry,
that's the best.
I feel very strongly about it. That's why I said so.
No, I'm glad you did, Mr. Datar. I think that is the purpose of devoting so much time to actually discussing both the Vodafone and Cairn cases, because they're individually important, but they also represent a broader policy issue that's faced this country for over a decade now. Arvind, Datar, Promod Nair, thank you very much for joining us here on Bloomberg Quint. And for those of you who are watching, thanks very much for watching.
And Menaka, happy